Hello students, during this session I am going to deal with 3 chapters, that's chapter 8, chapter 8a and chapter 9. Chapter 8 deals with accounts and audit, chapter 8a deals with competition appellate tribunal and chapter 9 deals with miscellaneous provisions of the act. We will start off with chapter 8 which talks about accounts and audit. Sections 50 to 53 deals with the manner in which the accounts have to be maintained and the accountability relating to it, and who holds a higher say in terms of transparency with regard to accounts. Section 50 talks about grants by central government. As we all understand, the central government holds the key role in terms of ensuring the implementation of the act. The central government will allocate a special fund called the competition fund, which will go to the benefit of the competition commission and to implement the provisions of this act. Section 52 talks about accounts and audit. Accounts and audit, basically there is an obligation upon the commission to maintain accounts and prepare audit reports as and when they will be called by the government of India. Section 53 mandates furnishing of returns to be filed to the central government. In just to understand these 4 sections, it deals with specifically allotment of competition fund to meet competition expenses, salary, etc. The Commission is obligated to maintain accounts in consultation with the Controller and Auditor General of India. Also, the Commission is also obligated to file its returns to the central government in the form and in manner as prescribed by the central government. These sections have been incorporated into the Act to provide more clarity and transparency with regard to the fund allocated to the Commission for implementing the provisions of this Act. With this, we will move on to the next chapter, which is chapter 8a, which deals with competition appellate tribunal and the powers of appellate tribunal and the powers of Supreme Court, so on and so forth. Before I begin to make you understand the working of competition appellate tribunal, let us understand the hierarchical structure laid down under the Act. If you look at the Competition Act, the Competition Act talks about establishment of a commission and its arm called the Director General's investigative team, and the orders of the commission, if any passed, are not challenged, it may tantamount to an arbitrary kind of an action for which appellate tribunal is created or established under this Act to check any orders which are not passed in accordance with the provision of the Act. For this purpose, the appellate tribunal has been constituted. Above appellate tribunal, the power is also conferred upon Supreme Court to review the orders passed by the competition appellate tribunal. With this understanding, let us move on to understand each of the provision that deals with the process in which the competition appellate tribunal adjudicates upon the orders passed by the commission and the Director General, its investigative arm. The first section that deals with establishment of appellate tribunal, section 53a. Section 53a talks about an obligation on the central government to establish a competition appellate tribunal which will hear all appeals against orders or directions passed by the commission under section 26(2) and section subsection 6 of 26 and section 27, section 28, sections 31, 32, 33, 38 and 39 and sections 43, 43a, 44, 45 or 46 of the Act. Power is conferred upon the Competition Appellate Tribunal to adjudicate on claims for compensation which may arise from the findings of the Commission or the orders of the Appellate Tribunal passed under section 42a or under section 53q subsection 2 and such other orders passed for recovery of compensation under section 53n. If you observe section 53a, 53a particularly talks about establishment of the Competition Appellate Tribunal, and it also talks about the kind of appeals that are maintainable as against specific orders from the orders passed by the Commission, and those specific orders passed by the Commission are mentioned in form of the sections which I just spelled out. With that, let us move on to the next provision. Section 53b talks about appeals to appellate tribunal. Under 53a, we understood what are the appeals that can be filed. I mean, what are the orders against which an appeal can be filed. Under section 53B, it says who can appeal to the Competition Appellate Tribunal. It says the central government or the state government, any local authority or any enterprise or any person aggrieved by an order referred to at section 53A subsection 1 and subsection A can prefer an appeal. This section 53A subsection 1 subsection A deals with those provisions under which orders of the Commission can be challenged by way of appeal before the Competition Appellate Tribunal. Under section 53B, it also lays down a timeline in which the appeal have to be moved. It says the appeal has to be filed within 60 days from the date of receipt of the order, and also confers power upon the appellate authority to condone the delay in terms of filing the appeal at its discretion when it feels it's reasonable, and if finds there are cogent reasons for the delay, reasons submitted by the person appealing which may be accepted by the Commission. All appeals, and there is also a mandate cast upon the Competition Appellate Tribunal to conduct the appeal proceedings in an expeditious manner and preferably be disposed within 6 months from the date of it being initiated. Let us move on to the next section. Section 53C talks about composition of the appellate tribunal, and section 53, I am reading two sections together, and section 53D talks about qualifications. Section 53 says that the Competition Appellate Tribunal shall comprise of 3 persons, that is headed by the chairman and 2 members. The chairman is, and as per qualifications discussed at section 53D, the chairman shall be the rank of judge of a Supreme Court or the Chief Justice of any High Court, and the other members, and the 2 members who will be on the board will have to have special knowledge in certain disciplines such as accountancy, international trade, law, and such specialized courses which are relevant for the purpose of adjudicating issues relating to under the Competition Act. Section 53E, the next section, talks about the selection committee. The selection committee basically comprises of the Chief Justice of India, Secretary to the Ministry of Corporate Affairs, and Secretary of Ministry of Law and Justice. It is this select committee which will choose the members and the chairperson of the Competition Appellate Tribunal. The next section we are going to discuss is section 53F, which talks about the term of the office of the chairman and the members of the appellate tribunal. The term prescribed under this section is 5 years. It also provides for a provision relating to reappointment, and the eligibility with regard to reappointment is that the post of the chairperson shall not exceed the age of 68 years, and the members shall not exceed the age of 65 years. So, it is clear that the term is set for 5 years. Then the age is also prescribed in terms of their re-eligibility under section 53F. Let us move on to the next section, that is section 53G, which talks about terms and conditions of service of the chairperson and the members of appellate tribunal. The terms and conditions on service of the members and the chairperson is purely dictated by the central government by virtue of taking out necessary notification from time to time. Section 53H generally talks about vacancies, which also is a prerogative of the central government, where the central government will notify and call for fresh appointments as and when there is a vacancy, and section 53H lays down the procedure for it. Section 53I deals with resignation of the chairperson and the members of the appellate tribunal. The only condition here which is relevant for our understanding is any member or the chairperson choosing to tender a resignation would have to give a 3 months notice or may have to continue in such position till a successor is appointed. Let us move on to the next section, that is section 53J. Section 53J talks about member of an appellate tribunal to act as chairperson in certain cases. If you were to recollect the provision of this section, it is almost similar to the competition commission, wherein the member of the commission would also act as a chairperson in the event of situations when the chairperson cannot be there to act as a chairperson. more or less the provision relates to the section that deals with member acting as chairperson in absence of the chairperson, and the procedure for it is dealt with under section 53J. Let's see the next section, that is section 53K. 53K talks about removal and suspension of the chairperson and members of the appellate tribunal. The rules for removal and suspension of the members are set out under section 53K, and the final order will vest with the central government, and the procedure for removal or suspension is laid down under section 53K. Let's see the next section, that is section 53L, which talks about restriction on employment of the chairperson and other members of appellate tribunal in certain cases. This section also correlates to the earlier section where we talked about similar kind of restriction laid down on the members of the commission and also member of the chairperson of the commission. What is important for us to understand here is, just like a restriction of 2 years has been laid down for the members of the commission, the similar restriction of 2 years has been laid down for the members and the chairperson of the competition appellate tribunal. And what is the restriction? For our understanding and to recollect, there is a 2 years embargo or a restriction from seizure of being employed with any of the enterprise which faced proceedings under this act before the members of the commission during their tenure. So, the catchword is simple: any enterprise which has already faced proceedings before the competition appellate tribunal, which is presided over by the chairperson or the members, then such members post resignation from their post cannot choose employment to work with this enterprise for a period of 2 years. The next sections are section 53M and section 53N, which talk about staff of the appellate tribunal. This provision also correlates the provision which we had dealt with with regard to establishment of the commission, wherein a provision is being provided for appointment of staff to assist the competition appellate tribunal to discharge its functions under this chapter. Let us move on to the next section, that is section 53N, which talks about awarding of compensation. You must be familiar with awarding of compensation is a situation that is dealt under section 42A, which is already discussed. Let us move on to understanding the language of section 53N and why is section 53N provided as an additional provision dealing with awarding of compensation. Section 53 says, without prejudice to the provision containing under the Act, the central government, the state government, or any local authority, or any enterprise, or any person may make an application to the tribunal, that is competition appellate tribunal, to adjudicate on the claim for compensation or orders in appellate tribunal in appeal against findings of the commission under section 42A or under section 53Q subsection 2 of the Act to pass an order for recovery of the compensation from the person who caused the damage. Here the key note is the person who caused the damage. We are dealing with a situation that is post adjudication. So, in this, a compensation is claimed against a person who is deemed to have committed an alleged offence which contravenes the provisions of the Competition Act. And it says further under section 53N, it says every such application shall be accompanied by the findings of the commission. You understand that commission is kind of an investigative agency, works through its arm, the Director General, and brings out the findings. Upon such findings, it passes the necessary orders on the persons who are stood to have been proven to have contravened the provisions of the Act. Further, under this section 53N, the appellate tribunal is obligated to conduct an inquiry, and after inquiry, it may pass orders for payment of compensation against the persons who contravene the provisions contained under chapter 2 of this Act. You must be familiar, chapter 2 talks about important sections which actually form the basis for which the entire machinery of the Competition Commission works to prevent. Just to recollect you, sections 3 to section 6 of chapter 2 deals with 3 situations, that is prohibited agreements, abuse of dominant positions, and formation of combinations and regulation of combinations. on these aspects if the appellate tribunal after inquiry finds a contravention. In such event, a claim for compensation is adjudicated. An award of compensation is also granted. Further, under section 53N, it says in the event if there are many applicants, because at the outset of discussion of section 53N, we discussed who can file an application. A person is also included to file an application. In the event if there are many applicants, say there are 100 applicants, then it says for clarity that one of the persons among those 100 applicants can make an application for claim of compensation before the Competition Appellate Tribunal. Under section 53N, it also says as to when does the process for claim of compensation begin. The section 53N states as follows, that the application for compensation can be made only after, please note this language, only after the Commission or the Appellate Tribunal on appeal before it under section 53A subsection 1 has determined in the proceedings before it that the violations of the provisions of the Act has taken place, or if the provisions of section 42A or subsection 2 of section 53Q are retracted. You must bear in mind as to these exact wordings of section 53N, which leaves a kind of a pre-requirement for the purpose of invoking the provision under section 53N for the purpose of claiming compensation. We are moving on to the next section, that is section 53O, which deals with the procedure and the powers of the Appellate Tribunal while discharging its functions as a Competition Appellate Tribunal. It says, Tribunal shall not be guided by the provisions of CPC, but it shall be guided by the principles of natural justice and shall have the powers to regulate its own procedure. For your understanding, let us understand the procedure that is to be followed by the Commission as stipulated under the section. Section 53O provides powers to the Competition Appellate Tribunal. The Appellate Tribunal shall be vested with similar powers like that of a civil court under Civil Procedure Code 1908 while trying suits. The tribunal shall also have power to summon, receive evidence, procure documents and call for production of documents. Further, it also has the power to appoint commissions. It also has the power to dismiss for default or set ex parte. The tribunal also enjoys power to requisition public records like under the provisions of sections 123 and 124 of the Indian Evidence Act. Further, the tribunal also has the power to review its own decisions, and for the purpose of the proceedings conducted by the tribunal are treated as judicial proceedings within the meaning of contained in sections 193 to 228 for the purpose of section 196 under IPC, and the tribunal shall be deemed to be a civil court for the purposes of section 195 and chapter 26 of the Criminal Procedure Code 1973. The procedure that I just discussed is just a brief powers of the Competition Appellate Tribunal for the purpose of dealing with appeals that come before it. The next important provision that is relevant for discussion is section 53P. Section 53P talks about execution of the orders of the Appellate Tribunal. Section 53P, it says the Appellate Tribunal will act as a executing court similar to that of a civil court, and to implement its orders, it may send its orders for execution through a court which is having local jurisdiction to execute the orders as if it were a decree of that particular court. For the purpose of our understanding, in a simpler sense, any orders of the Appellate Tribunal will be treated like a decree in a civil proceedings and will be executed in the same manner as a decree is executed. Further, section 53Q talks about contravention of the orders of the Appellate Tribunal. It says, if there is a contravention of the orders passed by the Appellate Tribunal, it will lead to penal consequences and a penalty not exceeding ₹1 crore or with imprisonment for a term up to 3 years or both may be imposed by the court of Chief Metropolitan Magistrate Court at Delhi, which is designated to deal with issues relating to contravention of the provisions of this Act, including when there is a contravention of the orders passed by the Appellate Tribunal. By now, you all must be familiar. Chief Metropolitan Magistrate Court is a designated court that is to take cognizance of offences that have been identified or found to be contravening the orders of the Commission or the orders of the Appellate Tribunal. And the Chief Metropolitan Magistrate will act upon only on the complaint given by the Competition Appellate Tribunal or through its authorized officer. This provision is similar to the provision which we had earlier discussed with regard to the implementation of the orders of the Commission in the chapter which deals with establishment of the Competition Commission. Moving further, the next section that is relevant is section 53R. Section 53R talks about a situation where there is vacancy in Appellate Tribunal not to invalidate acts or the proceedings. Now, this is also a similar provision which correlates a situation where the composition of the tribunal is vacated due to some vacancy. The orders passed by it are not affected by such defect in the composition which is caused due to vacancy of the members of the Competition Appellate Tribunal. The next section that is relevant is section 53S. Section 53S talks about the right to legal representation. Any person or enterprise aggrieved by an order has a right to be represented by a specialized person, and those persons who can represent a person or an enterprise or central government or state government are, he can be a company secretary or a chartered accountant or a legal practitioner. So, basically they have widened the scope of being represented through lawyers alone. Specialized experts such as company secretaries and chartered accountants are also permitted to represent a person before the Competition Appellate Tribunal. Next section that is relevant is section 53T. Section 53T talks about appeals to Supreme Court. This section provides that any orders passed by the Competition Appellate Tribunal can be taken on appeal before the Supreme Court within 60 days from the date of receipt of the orders of the tribunal, and in the event of delay caused of filing the appeal within the stipulated 60 days, the person filing an appeal may set out reasons for the delay caused, and the Supreme Court in its discretion may allow if the reasons provided are reasonable. There is a special power conferred upon the Competition Appellate Tribunal. This power is called the power of contempt. The power of contempt is discussed under section 53U. Section 53U provides the power of a contempt under the Contempt of Courts Act of 1971, recognizes the Competition Appellate Tribunal as in par with the High Court, and the provisions of the Contempt of Courts Act 1971 would apply to the Competition Appellate Tribunal. By conferring such a power, the Competition Appellate Tribunal would assume serious position in terms of conducting the proceedings before it in an effective manner. With the completion of chapter 8A, where we had comprehensively discussed the powers of the Competition Appellate Tribunal, we are going to move on to the next chapter, that is chapter 9, which talks about miscellaneous provisions of the Act. Please note, the chapter relating miscellaneous provision confers maximum power upon the central government to ensure to deal with any shortcomings, any eventualities that the Act might face in course of its implementation. Let's move on to understand the sections that are provided under chapter 9 of the Act. The first section that is important for our discussion is section 54. Section 54 talks about power to exempt. The power to exempt is conferred upon the central government to ensure there is an exemption given from application of this Act to certain enterprises or to certain activities which it feels relevant. Section that I will be discussing is section 55, which talks about power of central government to issue directions. The power of central government, again there is a power reserved upon the central government to issue necessary directions from time to time for effective implementation of the Act. Similarly, under section 56, a power is conferred upon the central government to supersede over the commission activities. However, there is a reasonable opportunity that has to be provided by the central government to the commission before it supersedes the orders of the commission. As I said at the very outset of the discussion, that this entire chapter deals with the powers of the central government to deal with effective implementation of the Act. But this one particular provision under section 56 gives the power of the central government to override the orders passed by the commission. Override order should not be understood in a negative connotation, but to be understood in a sense of superseding the orders passed by the commission for the purpose of implementation of the provisions of this Act. The next section is section 57. Section 57 confers a power upon the central government to lay down some restriction on disclosure of information. Section 57 in specific deals with restriction of information to be disclosed in aspects which do not relate to the provisions of this Act. For your understanding, it says that there is a legal embargo to disclose information received from any enterprise unless required as per the provisions of the Act. Unless there is a requirement under the provisions of the Act to disclose such information, no such information received by the commission shall be disclosed. This is the kind of restriction which is required in perhaps the best interest to ensure that certain confidential information does not go out of the purview of the Act. The next section that is relevant for discussion is section 58, which talks about chairpersons, members, director general, secretary, officers and other employees, etc., to be treated as public servants. For the purpose of our understanding, the definition of public servants is more familiar seen from section 21 of IPC. The reason why they are treated as public servants is, at times, no criminal prosecution can be allowed against a public servant when they are recognized as public servants under section 21 of IPC. Section 59 complements section 58, which says that every action discharged in course of duties contemplated under the Act, such actions are considered to be taken out in good faith, and a protection is conferred under section 59 of the Act. Moving on to the next section, that is section 60. Section 60 talks about Act to have an overriding effect. The term Act to have an overriding effect means that this law, which is considered a special law, will override all other laws that are for time being in force. Section 62, as I was saying before I read into section 61, I will deal with section 62, which provides a clarity with regard to section 60, which talks about Act to have an overriding effect. Section 62 says that application of other laws not barred, which means that this Act, that is the Competition Act, will be in addition to and as ancillary to the other laws that are already in force governing this issue relating to the competition regime in India. Both the sections, if you were to observe, it no doubt confers section 60 and 62 reading together. It confers a special status to this law, but at the same time it doesn't bar the application of other laws in course of dealing with competition related issue under this Act. Moving on to the next section, which is relevant, that is section 61. Section 61 excludes the jurisdiction of civil courts. As the language speaks, no civil court is permitted to entertain any issue which is raised under the provisions of this Act or pass any orders on it. This is an exclusive bar of civil jurisdiction. With that, we will move on to the next sections, that is section 63. Section 63 confers power upon the central government to make rules for implementing the provisions of the Act. Section 64 provides the power to make regulations. Both these powers under section 63 and 64 have been conferred upon the central government for the purpose of making such rules and regulations for effective implementation of the Act. The next section that is important is section 65, power to remove difficulties. Again, a power is conferred upon the central government from time to time to remove all such difficulties or embargoes that might come in way of effective implementation of the Competition Act. The last section that is relevant for discussion is repeal and saving. Power is conferred upon the central government again to repeal all such provisions of the Act which in the view of the central government are not relevant to be retained, and save such clauses which are relevant for the purpose of effective implementation of the Act. With this discussion of section 66, we have concluded a chapter of chapter 9, which deals with miscellaneous provisions of the Act. What is relevant for the purpose of our discussion and to bear in mind are certain important sections. Important sections such as 1. Exclusion of civil court jurisdiction. 2. Recognition of Competition Act as a special law, but it also allows the application of other laws to give effective implementation of the provisions of this Act, and the powers of the central government that are laid down in this chapter.